So, hi everybody, welcome back to Law Hero, and you are very welcome to the Law Hero lair, which is essentially this couch, and it's where I make my Law Hero videos. And tonight we are on the second last FE1 review video of November 2020 exams, which is criminal law. And yeah, we're getting very close to the FE1s now. They're on in a week or two. So yeah, like, watch all my videos. They're a great little review for yourself. And look, I know my hair is so awful and flat, but look, you're just gonna have to deal with it. So the exam is set by my dear Professor Shane Kilcummins. He has been doing it for years. He's a lovely, lovely professor. I had him in UCC for evidence, and then sadly he moved to UL, so they're very lucky to have him there. So the first question was a problem question, and with this question the best thing to do, as I always say, is look to what the question is asking. So the law on the mens rea requirement of intention. So the best thing to do there is speak about mens rea in a broad term, and then use the facts from the question, because you're not given those in an abstract. You are required to kind of apply mens rea to what's in front of you. And then you also had to answer the right to a presumption of innocence and how it would apply here. So basically this is somebody who is in a gang, and you know, her neighbor is a key prosecution witness, and she's been told like she will have her house burned down if she gives evidence. Actually, interestingly, this happened to me but it was a death threat actually. So I was actually a witness of a crime, and the culprit had seen me at the scene of the crime and had seen me ring the police. I was actually in Germany at the time, and they then proceeded to try and intimidate me over the course of a few weeks by standing outside my window and going like this to me, in that when the prosecutor, the state prosecutor, I was in Frankfurt, so it was the Hessen state prosecutor, would ring me, that I would refuse to give evidence. And actually what happened in the end was I didn't need to give evidence, because he was committed for another crime. So in the end I didn't have to give it, but I would have, as you all know. So obviously that was intimidation, and so here it says, the offence of intimidation of certain classes of person with the intention thereby of causing the investigation or the course of justice to be obstructed, perverted, or interfered with. You have to prove that an act of intimidation was committed shall be evidences that the act was done with the intention required. So obviously here she allegedly approached her and said her house would be burned to the ground. So here is the intimidator, you're her solicitor, and she asks you what is the mens rea requirement of intention, and she believes she's a right to be presumed of innocence, yet this section appears to relieve the prosecution of the requirement to prove the mens rea element of the offence, specifically an intention to pervert or interfere with the course of justice, with the intention thereby of causing the investigation or the course of justice to be obstructed or interfered with, and it provides that proof that an act of intimidation was committed shall be evidence that the act was done with the intention required. So as the question says, there is really no need here to prove intention. It's implied that the act combines the mens rea and actus reus in itself. So you'd need to talk about that. And then the presumption of innocence, that can sometimes be removed in certain statutory examples, just like the one here, like, or for example, like you're caught in the act, things like that. And the you know, there's a classic one in a hotel in Dublin where it's around, we'll say, drug offences, and the guy is found in possession of drugs and he's found caught in the act. So when they're arguing mens rea, it's irrelevant. Okay, so the second question, I'm not going to go down through it. It's an essay question, and it's around provocation as a defence, and you'll see in my ebook I cover that in the defences chapter. That was a fine essay. So question 3 was a problem question. So it was about a man who's not liked in his community. Grumpy man, not generous, made inappropriate statements and gestures. Most people tolerated him, but he was viewed as harmless. There's such an Irish thing. Oh, he's harmless. Like, when I think of other foreign languages or other kind of situations I've been in, it's only in Ireland you hear that phrase, harmless. And it normally means the person isn't harmless. So there's one individual who doesn't like this person, Michael. He's developed a tough reputation in the neighbourhood as a local enforcer. He was also an active member of a violent criminal gang. Despite the absence of any act of provocation, Michael decided he was going to teach Declan a lesson. So this is unprovoked. This is not in defence. So this is an intention to cause harm or assault. We'll see what it is. So he's met up with his 3 friends, Matt, Mark and Luke. So there's 4 people involved here. They're going to give him a lesson he won't forget. Armed themselves with weapons, hurleys, hockey stick, and they waited outside his house. When he came out, they attacked him. Okay, so various levels here of assault. They want to give him a lesson he wouldn't forget, which presumes they don't want to go as far as killing him, but they want to injure him very much so. So he collapsed, where he was further assaulted with blunt weapons and kicked. And at this point, he was stabbed. So we got some knife crimes in there as well. Remember, in these criminal law questions, there's always loads of different aspects. So 3 of them claimed they did not actually know he was going to stab and kill him. So the stabbing actually killed him. So that's causation. They didn't know he would kill him. That's true, but they did really want to seriously harm him, which could have resulted in death. So then we have to look at intention here. All 3, however, will make different claims in relation to their enterprise. Michael claims, so this is the ringleader, that he agreed and intended to cause serious harm to Declan, but never to kill him. Matt is one of the friends. He believed that they were only going to cause harm, and he never wanted to kill him. He also claims he only agreed to take part because he was afraid of Michael. So there's other stuff there. So if you're coerced into doing it, who threatened to beat him. Oh yeah, there you go. He took this seriously. And again, you don't question this if this is what the evidence said, this is what the evidence said. Mark, this is the other lad, claims he only agreed to commit an assault causing no more than harm to Declan. So a bit the same as Matt. He did foresee the possibility that Luke, who's also a member of the violent gang, might bring the knife because he often has a knife in him. He also did foresee that he might use the knife because he's that sort. So he has knowledge of. So this is all incitement and accessories to the fact. Nevertheless, he claimed that he proceeded with the enterprise with the most of intention to cause harm. Okay, so you have to go through the 4 of them, and that's pretty okay. Question 4, again, is a problem question, but it's more kind of descriptive in that, yeah, you have a client who is guilty of Section 3 assault, and the DPP are looking to either, so this is a hybrid, so they're going for a trial on indictment, and they'll say that the ordinary courts are inadequate. So this is a hybrid. This is a hybrid offence, so you have to classify offences. Again, you'll see this in the first chapter of my ebook, and then the scope composition of the SCC, the Special Criminal Court. This is in the final chapter. Then you get a 4-part question in question 5, and this is a problem question. And here, if I just go down through it, there are 4 different types of sexual offences. These are well covered in my sexual offences chapter. There is one vulnerable person, and there's some unmarried person, there's some children involved. So yeah. Question 6 is also a question from the DPP. The criminal liability arising from minors and kind of sexual assault between a 13-year-old and a 10-year-old girl. There was a question around bees being kept. So this person bought bees, and a few of the bees escaped. So this is around causation, and somebody who had a driving accident because of something outside, because of these bees that were let free. So yeah, that was fine. And then question 7 then was somebody who's after taking drugs and alcohol. There was a syringe attack, there was robbery, then obviously used the defense of taking drugs and alcohol. That is all covered in my ebook. And there's an assault causing harm. So the person who did this claims it was necessary in light of the initial attack, which was the syringe attack, and he also had some attachment to his wallet, which was stolen. So you have to advise both of these people on their criminal liability, and again, that was fine. The final question then seems to me have been looks like Theft and Fraud 2001 Act. So yeah, you have some jewellery stolen in the first one. You have some fraud around CEO points. You have randomly another sexual encounter, consensual sex. Oh, this is somebody who they believe, so this is the carnal knowledge piece. And then the final one seems to be again, theft and fraud. Sorry, it's actually an inchoate offence because they've agreed to do it, but they haven't done it yet. So yeah, it was a lovely criminal paper in my opinion. And interestingly, criminal was the only area this winter where nobody came to me having failed it. I know one person told me they failed it, but it seemed like they had too much information actually. So they had too much irrelevant information, and that seems to be, you know, usually if somebody fails an FE1, they either have learnt too much and throw it all down, and that really doesn't work with criminal law. And the other time is when they haven't learned enough and they can't answer the question. So it's normally an extreme between both. Very rarely do people give the wrong answer. You might see it in contract in the offer and acceptance question because so many people just don't understand offer and acceptance. But actually very rarely have I seen people put down the wrong answer. So yeah, get your information right, check out my ebook, and yeah, I'll see you in the last one, which is EU law.